What were you drinking then?
Twisted tea, Your Honor.
You just are continuing to consume alcohol. Quite frankly, need to go inpatient. I mean, you know you can't do this on your own.
Correct.
Mr. Duncan is the sole care provider for his 95-year-old mother. I don't necessarily disagree with what this court just stated, and I don't think Mr. Duncan does either. Would the court consider allowing him to be put onto a scram tether?
My point in that is it's highly intoxicated during the film. So that's certainly a concern if he were to be released even on a scram tether.
This defendant walked into court acting like a few excuses about failed. Drug tests would somehow convince the judge everything was under control. It's surprising how some people treat court hearings like optional obligations, especially when they're already facing serious charges. In this case, the prosecutor barely had to argue. The facts spoke for themselves, and they painted a clear picture of someone who probably shouldn't have been out on bond in the first place. It's the kind of situation where someone gets caught red-handed, but still insists nothing is wrong, even when everyone in the room knows better. What do you think? Should people like this get another chance on bond? Or should there be zero tolerance for violations? Let's take a closer look.
Hey, Dustin, just state your name for the record, please.
Dustin Duncan.
All right. Your Honor, thank you for recalling this matter. So based on Mr. Duncan's appearance, I would ask the court to withdraw the bench warrant.
What was his bench?
There's a bond by.
Yeah, no, I see it. Well, you see the violation. The violation was the reason that I issued the warrant in this case.
Right, Your Honor. I've discussed the bond violation with Mr. Duncan. And Your Honor, to his credit, he did contact his community corrections agent and admitted.
When did he do that?
To consuming alcohol. The report indicates that he did, or it may have been the email actually that was sent out by Mr. Casey, where it indicated that Mr. Duncan did call him and admitted to drinking a twisted tea on September 13th, which is what ultimately led to the positive test on that date. I mean, then obviously we do have other issues. I'm aware of that, but at least he did admit to consuming alcohol to his community corrections agent. I can tell you that based on my discussion with Mr. Duncan, he has started attending some meetings with the Alano Club. He has reached out to Home of New Vision. He's an admitted alcoholic, Your Honor.
You wrote a picket.
I understand all of that, but my other problem is that given the other sort of mistest, I mean, what about on, you say the twisted tea on the 13th, what about on August 30th? What were you drinking then?
Same twisted tea, Your Honor. I haven't contacted Home and New Vision Connection.
Well, I just said that, but you're welcome to say it if you'd like to.
No, I didn't start to contacted Mr. Leroy Get with Home and New Vision for a sponsor. I had 4 years clean and I relapsed. I know firsthand I need help with it.
Well, I understand all of that, sir, but so here's part of the problem that I'm having. Not only is there then these tests, he also has then missed tests, of which I would have to assume you're drinking.
Yes, I
So
will.
I'm going to ask you this. All right.
Okay.
I have a bunch of missed tests. But on August 30th, I have the alcohol shows up. On September 13th, alcohol shows up. And we have more missed tests. So between, I guess, the 16th, the date of this report, and the date you went on the tether back in August, how many times have you drank?
6 or 7. Maybe
Yeah.
8. I had 2 missed tests. I was in the hospital. But I did, yes, I did.
You just are continuing to consume alcohol. And you're playing with the testing so that it appears as though it's just a missed test, when in fact, what it is you're drinking.
Yes.
Quite frankly, need to go inpatient.
You're
I mean, you know you can't do this on your own.
Correct.
Mr. Bowling.
Your Honor, Mr. Duncan is the sole care provider for his 95-year-old mother. I don't necessarily disagree with what this court just stated, and I don't think Mr. Duncan does either. Would the court consider allowing him to be put onto a scram tether?
The moment the prosecutor mentioned that he had been out in traffic, waving a knife around, any sympathy quickly disappeared. It's hard to stand in front of a judge, talking about just one drink, when the actual behavior put people in real danger. Situations like that often lead to immediate custody, yet he still believed a monitoring tether was a realistic option. By that point, the judge seemed finished with the minimizing. You could see it in the way the excuses were no longer taken. Seriously, the defense attorney tried to present the situation in the best possible light, which is part of the job, but some cases simply can't be softened, no matter how they're framed. You could almost see the moment the defendant realized that his story wasn't holding up anymore. Some viewers will still argue that he deserved another chance. If that's your view, share why. It's a debate that comes up in almost every case like this. Let's continue.
The reality is, in this type of circumstance, that doesn't help.
If nothing else, maybe it would be a reminder with a device on his leg that maybe he needs to call a sponsor if he feels like he needs to drink, or that he needs to attend an online AA meeting at any time of the day. Maybe the tether on his body would give a little bit more reminder than the SoberLink sitting on the nightstand table or the couch side table.
People have some concerns.
Yes, go on.
Well, the allegations include that Mr. Duncan was highly intoxicated at the time, walking into traffic, wielding a knife, trying to punch cars, making statements to incite a fight, continued that type of behavior when police arrive to take him into custody. My point in that is he's highly intoxicated during these films. So that's certainly a concern if he were to be released, even on a scram tether. At most, I would think the court could maybe consider a release to long-term inpatient treatment if you were to take him into custody. Thank you.
To adjourn the defendant's probable cause conference to September 30th, 2025, 9 a.m. And at this time, given the violations, defendant's bond.
This hearing shows how quickly things can change in a courtroom. Addiction is a real struggle. But once public safety becomes an issue, judges often have little room for flexibility. When the risk to the community increases, protecting the public becomes the priority. Many people end up back in custody, not because of one mistake, but because they fail to be honest before the situation escalates. In this case, the judge focused on the responsibility to protect others first and consider personal circumstances second. It's difficult to argue with that approach. When the defendant kept pushing the limits until there were no options, left seeing someone remanded into custody, this quickly can serve as a reminder that bond conditions are not suggestions, their requirements do. You think the judge handled this fairly? Or would you have given one final chance? Thanks for watching. Don't forget to like and subscribe, and as always, take care.